Article 3. 8. Payable to bearer or order. 1. What is a GSE infographic? Well, a couple of months ago, I had a bunch of clients that were asking me for a better way to explain to them the analysis that mortgage compliance investigators put out. So what I came up was with an infographic. It is a graphic visual representation of information and data for government-sponsored entities. It was designed to present complex information quickly and clearly. Who created and why? I created the infographics, Joseph Esquivel, to complement chain of title analysis, again, that mortgage compliant investigators put out. What is a chain of title analysis? It is a comprehensive, state-specific chain of title analysis addressing securitization and foreclosure issues surrounding the power of sale claims against real property, using statutory requirements of law for each specific state, and using loan documents and public record. The analysis states what was to take place, what did take place, and also, most importantly, what did not take place. All right, so now I would like to go over some information so that everyone is on the same page of knowledge as to what is a GSE, because there's a lot of misinformation out there, along with what is the role of the GSE and who is a true GSE today. So, GSEs are known as government-sponsored enterprises. The first entity is Federal National Mortgage Association, going by the initials FNMA, and it's better known as Fannie Mae. So Fannie Mae is federally chartered. However, it is a privately owned corporation, and it exists under the Federal National Mortgage Association Charter Act. They were established in 1938 as a United States government agency which was designed to provide liquidity to the mortgage market. And in 1968, it was transformed into a public stockholder and privately managed corporation when they retired the government-held stock that they had, and also by legislation. However, Congress does continue to provide the charter under which the company operates. However, there is no financial backing. So when a loan that is alleged to be owned by Fannie Mae defaults, Fannie Mae is responsible for it. It is not government backed. And since Fannie Mae is a publicly traded company, the main consideration is to produce a profit. In terms of assets, it is one of the largest corporations in America. Freddie Mac is the Federal Home Loan Mortgage Corporation, or it also goes by the initials FHLMC. The name Freddie Mac is actually an acronym of the company's full name that had been adopted for ease of identification. Freddie Mac is also called Fannie Mae's little brother because when it was created in 1969, it was created to provide competition to Fannie Mae. Freddie Mac was also chartered by Congress as a private corporation. It's always been private. Freddie Mac was created so that Fannie Mae would not have a monopoly on the government-backed mortgages at that time. And there are more similarities in Freddie Mac and Fannie Mae than there are differences. Some of the differences that are in Fannie Mae and Freddie Mac are in regards to the down payment options. While Fannie Mae allows borrowers to put down as little as 3%, Freddie Mac does not allow loans of more than 95% to loan to value, which basically means that a borrower must have 5% down payment. Now, both Fannie Mae and Freddie Mac do allow for special gifts, grants, and they have programs that can help lower the amount of the down payment for borrowers as well. Now, Fannie Mae and Freddie Mac were supposed to just simply buy mortgages and then repack them and sell them on the secondary market. However, what they had found out was that by holding many of these products, it was actually more profitable for them. Now, the main difference between this company, Fannie Mae and Freddie Mac, again, lies in the government backing. It is only perceived. Freddie Mac and Fannie Mae are not backed by the government. The last GSE is a true GSE, and that is Ginnie Mae. Ginnie Mae, is a true GSE. 95% of all home loans that go through FHA, Federal Housing Authority, and the VA, the Veterans Administration, are backed by Ginnie Mae. So what this means is that this is actually better than gold. This is better than the CDs because it is truly a government-sponsored entity and is backed by the government. Okay, so now let's go over some verbiage definitions because as I'm speaking, I would like everyone to have an understanding of what we're talking about. Many times, I'm told that I speak in another language. It's not another language. The words are real. We just need to have a better understanding. One, what is a mortgage loan? A mortgage loan is a loan secured by real property through the use of a tangible promissory note, which evidences the debt and the encumbrance of property rights through the granting of a mortgage or deed of trust, which secures the loan. However, the word mortgage alone in everyday usage is more often used to mean mortgage loan. And it's more than not, that is how it is used. When someone says, oh yes, my mortgage, they're talking about actually the mortgage loan. Tangible promissory note. Tangible means that we can touch it. A tangible promissory note is a piece of paper that can be touched, that contains the promise to pay, but the real significance is not the physical paper, but the legal right which the paper confers. And hence, the promissory note is defined by the legal debt. The note is a tangible, negotiable instrument that evidences the intangible obligation. Security instrument. The mortgage or deed of trust, or if you're in the state of Georgia, would be the security deed, is seen as a real property lien if filed of record. Again, if filed of record. And it is a separate contract listing an alternative means for collecting payment due under the intangible obligation, evidenced by the tangible promissory note. The entire instrument is comprised of both documents, the tangible promissory note, the tangible security instrument, which would either be a mortgage or deed of trust, along with the intangible obligation. For there to be a right to enforce any part of the entire instrument, all three parts, tangible and intangible, must be named to the same party. Again, must be named to the same party. In the case of the tangible security instrument named in public record, and in the case of the tangible promissory note on the document itself, and in the case of the intangible obligation in the transferable record. Tangible obligor, the party whom signed the tangible promissory note. Tangible obligee, the party whom is named on the tangible promissory note, either as lender or is properly named as payee on a payee line physically affixed to the tangible promissory note. Intangible obligor. This is the party that creates the intangible obligation using the intangible payment stream of the tangible promissory note. Intangible obligee is the party that purchases the intangible obligation from the intangible obligor. They could be named Fannie Mae, Freddie Mac, or Ginnie Mae. They are seldom filed of record as a secured. I believe I have seen less than a handful of times, I can count on one hand and have fingers left over, of the number of times that I have seen either Fannie Mae, Freddie Mac, or Ginnie Mae listed into public record, and each of those times the loan amount was over $1 million, and it was for either a commercial property or an apartment complex. I have never seen it listed as a residential property being a secured party. Account debtor. This is a real word. Account debtor is also an originator. Under UCC Article 9, under Secure Transactions of Part 1, 9-102, in the definitions and index of definitions, we have account. Acceptation account, which means a right to payment of a monetary obligation, whether or not earned by performance. Okay. For property that has been or is to be sold, leased, licensed, assigned, or otherwise disposed. For services rendered or for services. For a policy of insurance issued or to be issued. For a secondary obligation incurred or to be incurred. For energy provided or to be provided. For the use or hire of a vessel under a charter or other contract arising out of use of a credit card. This is all under the definition of account. You can read it a little better later when it's in full. If we go down to 3, account debtor. Account debtor in the definition says account debtor means a person obligated on an account, chattel paper, or general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. So again, account debtor means a person obligated on an account. Okay? It does not include the persons obligated to pay a negotiable instrument. This is the creator of the intangible obligation. MERS. We hear a lot of talk about MERS. What is MERS? Mortgage Electronic Registration Systems Incorporated. They go by the acronym of MERS or just plain MERS. They're a wholly owned subsidiary of MERS Corp. Incorporated and serves as mortgagee in a nominee capacity for the lender and subsequent assignees. An electronic database that is used to track the intangible obligation as well as the servicing rights. Again, an electronic database that is used to track the intangible obligation as well as servicing rights. They do not operate in the tangible world. So, again, they do not operate in the tangible world. They operate on the intangible world. MERS Corp. Incorporated is a privately held shareholder corporation that operates the electronic database that is used for tracking interest in mortgage loans as well as the servicing rights of the loans. I know many people that I have talked to time and time again have said that, well, MERS tracks the note. They need to be more explicit in what they're talking about. All right? What note? There is more than one note. There is a tangible promissory note, and there is an electronic note. Again, MERS operates in the intangible world, so they would track the interest that is intangible in the mortgage loans as well as the servicing rights. They do not operate in the tangible world. Okay, a lot of this information all boils down to title. What is title? Everybody has a misconception. There's 10 different definitions out there. So what I put together is what I believe title is the union of all elements constituting the legal right to control and dispose of property. 2, the legal link between a person who owns property and the property itself. 3, the legal evidence of a person's ownership rights, parentheses, interest in the property. Title is the manner in which the right to real property is acquired. The conditions necessary to acquire a valid claim to land. Title is the right itself, the legal consequences of such conditions. Again, it's all about rights. Okay, with that being said, let's get started on these infographics that I have created. Again, the main reason of the creation of these documents, the infographics, was to put on one document what a 20 to 30 page analysis consists of in a very simple format. So what we are going to do is we're going to start out, okay. This is the entire infographic. This one is requirements for securitization using MERS, okay, of Fannie Mae loans per Fannie Mae documents. Okay, so what I've done is I've gone through a plethora of documents for Fannie Mae, Ginnie Mae, Freddie Mac. For Fannie Mae alone, we've gone through the selling guide, which is about 1,452 pages, the servicing guide. We've gone through the custodian of documents. We've gone through electronic warehouse lending. In total, we probably have about 5,000 pages of documents for Fannie Mae alone. So when we say per Fannie Mae documents, this is the verbiage taken from the Fannie Mae documents. These are their business practice as to what happens. So we're going to start from the top, and we're going to use John Doe. Along with John Doe, we're going to use Countrywide because Countrywide's been around for a while. So we have a borrower, and the borrower is John Doe. John Doe goes to the title company, and on March 14th of 05, okay, he's at title, and he signs roughly anywhere between 60 and 80 documents. Now, within these documents, there is a tangible promissory note, which is the Doe note, and there is a security instrument that we're going to call the Doe mortgage. Okay, within this Doe mortgage, MERS is named on the mortgage. So, in this case, it would be named as a mortgagee. Now, also within the tangible promissory note, there is a payment obligation. That is right there. Okay, so after closing, the Doe mortgage gets sent to the county recorder's office. When it's at the county recorder's office, it's filed of record, it's indexed, and it's recorded. After it's recorded, it's sent back to the lender. In this case, it's Countrywide Home Loans. Okay, at this time, the tangible note and the tangible Doe mortgage have been properly filed of record and perfected. There is now an encumbrance on the property. Okay, now, meanwhile, after the county recorder sent the security instrument back to Countrywide Home Loans, what happens? Well, let's take a look. Within the first 24 to 48 hours, the paper note is scanned into the system, and it's stamped with a payee on named, and then delivered to the custodian. Now, there is a deposition of the Southlander out, and I believe it's on page 54 that she states the same verbiage. Michelle Southlander used to work at Countrywide Home Loans as a senior vice president, and after Bank of America acquired Countrywide Home Loans in a portfolio buyout of February 08, she got a new job as vice president with Bank of America. Okay, so again, the verbiage is within her deposition. It is also on our script page in one of our collections as well. So what happens is that the paper note is scanned into the imaging system, and it's stamped with a payee on named. It says, pay to the order of without recourse. That is a stamp. That's all it is. Okay? At the same time, an electronic copy is made of the note. Again, electronic copy. They call it an authoritative copy, and that information is sent to MERS, Mortgage Electronic Registration System. Okay? Shortly after that happens, the intangible payment obligation is stripped and transferred electronically and sold to, in this case, Fannie Mae, Federal National Mortgage Association, also known as Fannie Mae. So, the payment obligation is stripped out of the note. The payment obligation is your promise to pay. I promise to pay for the next 360 months $1,000 a month. That is what is sold. Many times I hear attorneys say, Joe, you don't understand, they sold the note. No, what they're selling is a payment obligation, a right to receive future payments. This is legal. They do it all day long under Article 9. Imagine as if you had a strip mall, and within this mall you had 10 stores, and you had 10 tenants within these stores. Now you've fallen behind in your bills and you have no extra money to pay your creditors. What you could do, you could sell the leases, which contain the right to future payments, to your creditor. It's legal. It's done all day long, millions of times a day. So now look at the note. We have a tangible promissory note with a payment obligation. The payment obligation, okay, is stripped from the note and it's transferred electronically. Now, the note is still staying up here. They've sent that to warehouse. Okay? However, this tangible note is no longer eligible for negotiation pursuant to UCC 3203D. Now, depending on what state you are in, is depending on what statute you would have for your particular situation. Again, every state has codified a different set of statutory requirements. If you're in New York, you're going to use UCC 1961, and you must be specific, and that's what we are. So for me, whether you're in Maine, Idaho, or Hawaii, again, the statutes that are applied pursuant to your state. Very, very important. Okay, so let's look down here. So now, Fannie Mae has received this. They've bought in this payment obligation. What Fannie Mae does now, one, they record with MERS what happened. Boom, there they go. They tell MERS, okay, we bought this. We bought this payment obligation. Okay, we didn't buy the note. We bought the payment obligation. Okay, now a second intangible obligation is created by Fannie Mae. This is an intangible payment obligation, is pledged as collateral. In this case, we're going to use Fannie Mae Trust 2005-6. So depending on whatever trust the party is in, that is what would be placed there. Okay, so in this case, it's Fannie Mae Trust 2005-6. Now, this intangible is secured by the intangible payment stream of John Doe's note. Okay? Now, Fannie Mae Trust 2005-6 now puts this into certificates. And they sell these certificates to investors. The investors think that they are purchasing certificates backed by secured mortgages. That could not be further from the truth. At no time has this intangible payment obligation ever been secured to the John Doe mortgage. None of these parties have been filed with the county recorder's office. There has been no proper sale, transfer, and delivery of the instrument, the entire instrument. Okay, so right now what we're looking at is just a payment intangible. Okay, now, years later, upon default, okay, 5 or 10 years later, there's a default. Okay, now, upon default, a document purporting to be in an assignment is recorded in the servicer's name, with MERS listed as the assignee. They want the parties to believe that the servicer now has an agency relationship with MERS and they are official. Okay? However, the purported assignment transferred nothing, as the intangible payment obligation, the debt, has already been stripped from the tangible note. The recording of the assignment does not memorialize either the sale or negotiation of the tangible note. Again, all they bought was a payment intangible obligation. That's all they purchased. Within MERS own documents, they say they are to receive a note that has been stamped, paid to the order of, without recourse. It is not to be filled in with the name Federal National Mortgage Association. There is no assignment recorded into public. The servicer, okay, is the servicer of intangible payments. Intangible payments, not the tangible note. Again, the tangible note has been left in the warehouse. They often confuse people because they are talking about two different notes. They're talking about the electronic note that they created. However, pursuant to 15 U.S.C. 7003, Article 3 and Article 9 are excluded. There are no tangible laws in commerce regarding electronic copies. They use a lot of word crafting out there to make you believe that they are talking about the tangible when they are talking about the intangible. Okay, so the statute that we're going to be talking about is with the Uniform Commercial Code, 3-203. Under Negotiable Instruments, Part 2, Negotiation, Transfer, and Endorsement. Okay, under 3203, Transfer of Instrument, Rights, acquired by transfer. Again, it's not talking about ownership, it's talking about rights acquired. A defines what is to be done. An instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving to the person receiving delivery the right to enforce the instrument. Okay, so now we have it's defined. It tells how it is transferred. Instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving it to the person receiving delivery the right to enforce the instrument. Okay. Now, B, C, and D restrict what is to be done. 3203B, transfer of an instrument, whether or not the transfer is a negotiation, vests in the transferee any right of the transfer to enforce the instrument, including any right as a holder in due course. But the transferee cannot acquire rights of a holder in due course by a transfer, directly or indirectly, from a holder in due course if the transferee engaged in fraud or illegality affecting the instrument. Let me ask everybody out there. You ever receive any cases where fraud might be involved? Think about it. 3203C. Unless otherwise agreed, if an instrument is transferred for value and the transferee does not become a holder because a lack of endorsement, again, lack of endorsement by the transfer, the transferee has a specifically enforceable right to the unqualified endorsement of the transfer. But negotiation of the instrument does not occur, again, not occur until the endorsement is made. All right, so everybody understands. It says negotiation of the instrument does not occur until the endorsement is made. 3203D. If a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this article and has only the rights of a partial assignee. Okay, so if we look back as to what comprises an entire instrument, the tangible promissory note, the security instrument, and the payment obligation. For all three to be named to the sole payee, the same payee, because to just have a note or to just have the mortgage, you have only partial cause of action. In order to have enforceability to foreclose, you must have the entire instrument. If you have the entire instrument, okay, then, okay, you do have transfer and negotiation of rights. Okay, so let's get started. We're going to go over real quick, and we're going to go into a Freddie Mac. Now for Freddie Mac, again, this is the brother of Fannie Mae. So all of the basic structures are the same. Okay, the only difference is, in this one, there is no MERS. Okay, so we have a borrower. Okay, we have an originator, Countrywide Home Loans. Okay, in this case, John Doe was at signing and title. He signed a note and a mortgage. Okay, the mortgage was sent to County Recorder's Office. It was filed, indexed, and recorded. It was sent back to the originator, and we had perfection. We had the John Doe note, we had the John Doe mortgage, and we had the application. So at this point in time, there was a properly perfected lien on the loan. Okay, however, within 24 to 48 hours of coming to Countrywide Home Loans, the paper note is scanned to the system, stamped with a payee unnamed, and then delivered to the custodian, along with the mortgage, all the documents. Okay, at that time, the security instrument is no longer secured to the tangible note because the payment obligation has been stripped out, sold, and transferred electronically, in this case to Federal Home Loan Mortgage Corporation. When they did that, pursuant to 3203D, the tangible note is no longer eligible for negotiation pursuant to Uniform Commercial Code 3-203D. Because it was less than the entire instrument, the only thing that Freddie Mac is buying is his payment obligation. Okay, at that time, Freddie Mac has this payment obligation, and Freddie Mac creates a second intangible obligation. All right, this second intangible obligation is put into certificates, and it is pledged as collateral to the Freddie Mac Trust, again in this case 2005-6, and it is secured by the intangible payment stream. Okay? Now again, once it is in the certificates, the investors are thinking that they have a mortgage-backed security. However, it has never been properly negotiated. Okay, right here. Because all they bought was an intangible obligation, the note was never properly negotiated, transferred, and delivered. The mortgage was never leased, assigned, and transferred. Nothing was ever recorded at the county recorder's office. So there's an invisible line, because as the originator, Countrywide switched hats when they pulled out this payment obligation, and they wore the hat of the account debtor. So imagine an invisible line going across. The homeowners are not party to crossing this line. However, the investors cannot cross this line either. All they can do is go to the account debtor or the originator, because they were the creator of this payment obligation that was sold to Freddie Mac. Now, what else happens is that an assignment listing Freddie Mac as assignee is created in recordable form, but not actually recorded. And this is as described in third-party custodian Freddie Mac Form 1035A, Revision 8, Section 3. This is quoted directly from that form. A determination of the assignment of the security instrument from the seller servicer to Freddie Mac is duly completed and executed and in form suitable for recording, but not recorded, and that all intervening assignments have been duly completed, executed, and recorded. Therefore, while the security instrument is purported to have been assigned to Freddie Mac, again, purported, it has not, such assignment was not assigned of record. If the assignment had been filed of record, then Freddie Mac could have been a party identified to file for lien perfection. As a security instrument cannot be separated from the note, any negotiation of the note would have required an assignment of the security instrument from the original lender to the subsequent owner of the note. Therefore, any sale or transfer of ownership of the note without effectively assigning the security instrument would render the sale as selling an unsecured obligation. So when this payment obligation is stripped out, it reduces the value of the security instrument. In addition, in Carpenter v. Long in 1872, it is stated, the mortgage cannot survive a moment without the debt. So if the debt is stripped and sold, the mortgage no longer has debt to attach to, and thus becomes a nullity. It is not voidable, it is not voided, it is a nullity. Okay, Ginnie Mae, again, the same as Freddie Mac and Fannie Mae. The only thing different is the agency that sold the obligation. And this one is with MERS. Again, all of the parties are the same. Okay, the only difference is Ginnie Mae is truly backed by the government. Okay, so let's jump on to Fannie Mae without MERS. Okay, with Fannie Mae without MERS, again, very similar to Freddie Mac, very similar to Ginnie Mae. The difference is right here. Okay, without MERS, it says an assignment listing Fannie Mae as assignee is created in recordable form, but not actually recorded. As described in Section 8.2, Assignment of Mortgage and Fannie Mae Requirements for Custodians. Quote, the assignment is in recordable form, but is not recorded. Recordable form is generally whatever form the local recorder's office requires, and virtually all require the form be notarized. Again, therefore, the security instrument is purported to have been assigned to Fannie Mae, and such assignment was never assigned of record. If the assignment had been filed of record, then in this case, Fannie Mae could have been a party identified to allow for lien perfection. Okay, so let's go over a little bit more verbiage. Okay, this is under Uniform Commercial Code, Article 3. The purpose behind UCC Article 3 is to enable paper substitutes for money to change hands, be negotiated as easily as money. 2, enables a remote taker of an instrument to ascertain their potential rights on the instrument by looking at its face. Need to answer 4 basic questions. Is the paper in negotiable form? B, does the person wanting to negotiate or transfer the instrument qualify as a holder? C, do they qualify as a holder in due course? Or D, and D, what defenses are available to defeat payment? Negotiability. The magic words of negotiability requires that the instrument be payable to either the order of a named person or bearer. Recall, the purpose of UCC 3 is to enable paper to be as transferable as money. If paper is payable to bearer, anyone in possession can negotiate. But if payable to John Doe, then only he can negotiate, cash it, and it is not transferable. Thus, it would defeat the purpose of UCC 3. So again, it must be payable to either the order of a named person, again, named person, or to bearer. I've yet to see any promissory note made out to a person named bearer. Holder. In order to qualify as a holder, the party must have taken the instrument either by issue or negotiation. Again, by issue or negotiation. Negotiation applies to all latter transfers of the instrument. How negotiation occurs depends on whether the instrument is bearer or order paper. If bearer paper, then all that is necessary for negotiation is delivery. If order paper, then endorsement and delivery are necessary for negotiation to occur. Note, a person who has given value for order paper has a right to an endorsement. Again, if order paper, then endorsement and delivery are necessary for negotiation to occur. Endorsements. There are 4 types of possible endorsements under UCC Article 3. Blank endorsement, special endorsement, qualified endorsement, and restrictive endorsement. Blank endorsement. Blank endorsement or endorsement in blank results when the endorser only signs their name. This always creates bearer paper. Now, contrary to what the banks say, Article 3 says blank endorsement results when the endorser signs their name. That is what a blank endorsement is. It is not the bank's interpretation of their definition. What is a special endorsement? A special endorsement results when the endorser makes the instrument payable to a named person. Always creates order paper. Paid to the order of. Okay, imagine that you have a check. And you have the check and you fill out the amount, $1,000. You date it. You sign it. However, you don't name anybody on the payee line. And you go to the bank. And it's done millions of times. How many times have you written a check, forgot to put a named payee, and you go to try and cash a check? Or you hand the check to somebody, and they say, I can't cash this. Why not? You need to write your name in. Until a party is named as a payee, negotiation cannot take place. Has anybody ever gone to the bank and cashed a check without a named payee? And then when there is a named payee and that party signs their back of their check, what is the first thing they say? I need to see some identification. You need to identify yourself. Okay, the next we have qualified endorsement. A qualified endorsement results when the endorser writes, without recourse. This has the effect of limiting the endorser's secondary contract liability on the instrument. The endorsement does not limit the warranty liability. If you want to have fun, take a check, make it up for $5, make it out to cash, and then when you go to the bank and cash it, write without recourse on top of the signature line. And see what happens. I'm not going to tell you what happens, but just try it. I guarantee you'll have fun. Your teller may not like you, but you'll have fun. Okay, what is a restrictive endorsement? Restrictive endorsement is created as follows. A, words indicating a specific purpose. Example, for deposit only. B, endorsements imposing a condition. Pay Mary Smith upon delivery of the goods. C, words that attempt to prohibit further. Example, pay Mac company only. Now, although these terms appear to preclude further transfer negotiation by anyone, that is not the case. Now, I'd like to go over Uniform Commercial Code, Article 3. Okay. We talk a lot about bearer paper. The banks talk about it all the time. I have bearer paper. Let's see what bearer paper is. Under Uniform Commercial Code, Article 3-109, payable to bearer or to order. A promise or order is payable to bearer if it states that it is payable to bearer or to the order of bearer, or otherwise indicates that the person in possession of the promise or order is entitled to payment. Again, states that it is payable to bearer or to the order of bearer. 2, does not state a payee. Or 3, states that it is payable to or to the order of cash, or otherwise indicates that it is not payable to an identified person. B, a promise or order that is not payable to bearer is payable to order if it is payable to the order of an identified person or to an identified person or order. A promise or order that is payable to order is payable to the identified person. Again, on all of these documents that I've seen over the last couple of years, I have yet to see one that says payable to bearer. What it says is pay to the order of. There's specific intent. It says without recourse. There is specific verbiage defining what is to be done and to whom. Okay, let's go to C. An instrument payable to bearer may become payable to an identified person if it is specially endorsed pursuant 3205A. An instrument payable to an identified person may become payable to bearer if it is endorsed to blank pursuant to section 3205B. Again, what is an endorsement in blank? An endorsement in blank is when you sign your name to the payee line. A payee line with an unnamed payee is not a blank endorsement. Okay, now let's have a little fun. John Doe, we were talking about in the Freddie, Fannie, and Ginnie Mae charts. Now, let's take a look at this page and think about a minute what we've gone over for the past hour, and let's apply it to this tangible John Doe note. Okay, I got hold of the John Doe note, and on this particular note, I've noticed, okay, it's got some things at the bottom of the note. Okay, so let's talk about it for a minute. Okay, under UCC 7501, under form of negotiation requirements of due negotiation, A, the following rules apply to a negotiable document of title. 1, if the document's original terms run to the order of a named person, the document is negotiated by the named person's endorsement and delivery. Okay, the named person's, okay, endorsement and delivery. Okay, a loan. Okay, the Doe note has also been endorsed by Countrywide Bank FSB. Okay, Countrywide Bank FSB. The endorsement says, pay to the order of Countrywide Home Loans, Inc., without recourse. This constitutes a negotiation under UCC Article 3 concerning negotiable instruments. With a payee named, clearly Countrywide Bank FSB has released and transferred all rights to the Doe note to Countrywide Home Loans, Inc. The Doe note has also been signed by Countrywide Home Loans, Inc. Okay? The instructions preceding the signature states, pay to the order of, oops, wait a minute, there's an unnamed payee line. Without recourse is underneath. Okay, so pay to the order of, we're waiting for the unnamed payee. Okay. Now, with the instructions of the signer incomplete, this signature, okay, does not constitute a negotiation under UCC Article 3, and it is not an endorsement in blank. With no payee yet named, no transfer has occurred through which rights can be acquired. Countrywide Home Loans, Inc., okay, Countrywide Home Loans, Inc., along with signing away all rights to the Doe note, wrote instructions that made its intention of negotiation clear. Pay to the order of. You can't be any more clear than that. The clear intention was that Countrywide Home Loans, Inc. negotiation of the Doe note will only be complete when the payee is named. The Doe note with an as of yet unnamed payee is not and cannot be treated as a bearer instrument, as no person will acquire any rights to the Doe note until a person is named. Okay, so I'd like you to, again, look at what's in front of you on the screen. So now you can see what the banks say and what we're talking about tonight are two different things. So I hope I've given you enough information in this fight. And if we have any attorneys out there, I'd like you to roll up your sleeves, take off the gloves and get into the fight. And mortgage compliance investigators, on behalf of myself, Joe Quavell, and all of us here at Mortgage Compliance Investigators, would like to thank you for joining us today in our webinar. For information on receiving a chain of title analysis, you may call us at 888-491-3741, or you can email us at info@mortgagecomplianceinvestigators.com. We will be having another free webinar in about 2 weeks, and we will be going over RMBS infographics. RMBS stands for Residential Mortgage-Backed Securities. And I can tell you that you are going to love it. 2 weeks after that, we're going to have another webinar on MERS, everybody's favorite. And then shortly after that, we will be doing a live seminar, 8 hours. I guarantee you're going to be jumping off your seat for the information. So let's roll up our sleeves, get together, and call us for more information. We're here, and we'd like to talk to you. With that, have a great night, and thank you very much.